Okay, I'm John Kraft. I've got Kirk Allen, and we're both with the Edgar County Watchdogs, and Tom DeVore is an attorney. That's the attorney for Darren Bailey and several other people that filed lawsuits in 3 or 4 or maybe 5 different counties. We're here to get an update on those lawsuits. So, Mr. DeVore, if you would like to take over and just provide us, where it came from, where it is now, and what you think are the next steps for it.
Well, the case that originated out of Clay County with Mr. Bailey, that really takes on some of the broader issues of the governor's ability to issue disaster proclamations serially. So, meaning he can do one after the other after the other. And when he does that, does that give him the ability to re-energize or to have an additional 30 days of emergency powers? However broad those powers might be is a separate conversation, but whether he can have those emergency powers under Section 7 of the Emergency Management Agency Act, as long as he continues to issue these serial proclamations. I mean, that's the main issue in Mr. Bailey's case, and that's the issue that eventually is going to make its way to the Illinois Supreme Court at some point in time. So the case has been transferred to Sangamon County. It's in Sangamon County. It has been for a few months. The governor's office has asked the Sangamon County Court to reconsider Judge McKinney's decision back in July, where Judge McKinney ruled that the governor has the ability to issue these serial proclamations of disaster every 30 days. So that is actually in front of the Sangamon County Court right now, and the judge will consider that next week. Since the time that Judge McKinney issued that ruling in July, there was some other parties that had a case up north in the 2nd District of Illinois, where the 2nd District of Illinois Appellate Court said that the governor does have the ability to issue these 30-day serial proclamations. I wasn't involved in that case. There's a lot of issues with that case that I think need to be cleaned up at some point in time. But nonetheless, the Sangamon County Court is bound by that order until another appellate court or the Supreme Court rules on it as well. So the court in Sangamon County has no discretion as it relates to what would be known as count 2 of Mr. Bailey's complaint. She has to reconsider and set that aside at the moment. She doesn't have any discretion because, again, of a completely unrelated case up north. So once that happens, that'll probably happen next week. Then we will continue in that case because the case doesn't go away. We will argue again in front of her probably at the beginning of the year my client's position on why the 30 days is improper, which I think, again, we can do a better job of that, which will ultimately get that in front of the 4th appellate district here in Springfield, and they will take that issue up. But I've talked to the governors through the Attorney General's office attorneys. We talk about this stuff quite a bit, and we're both completely on the same page that we have to get these big issues in front of the Illinois Supreme Court sometime at the beginning of 2021 so they can give some clarity to this. And I would say that, that's how it's going to proceed unless and until we have a legislative branch of government actually convene and provide that clarity through an amendment to the legislative act. That would be the most appropriate way to deal with this, for the legislature to come and do a better job of saying exactly what that law should say, again, one way or the other, because the attorney for the Attorney General's office and myself, we both agree that that act is horribly drafted. And so they could provide some clarity. Otherwise, the Illinois Supreme Court's going to have to try to figure out what the legislature meant. And so that's really what's going on with Mr. Bailey's case.
Well, you're not holding your breath for the legislature, are you?
I'm not holding my breath for the legislature, sadly. It's unfortunate, of all the goings on in the last 9 months. I've never been a big fan of a lot of the policies that Governor Pritzker has enacted. I think he's went beyond his authority. But having said that, the legislative branch has been completely non-existent. They should have convened themselves months ago to try to help deal with this issue, and they didn't. So they're more culpable, in my opinion, than the governor's office is.
Do you know if the case in the 2nd district or the 2nd appellate district Is that one being appealed to the Supreme Court?
My understanding is that the attorneys for that did ask for the Supreme Court to take that issue on. I don't know if they will. I've not heard. My instinct tells me, since that was an interlocutory appeal, which means that it wasn't on the merits, as you guys are aware. So,
Right.
they has to take up an interlocutory appeal on that issue. And so, I don't know that they will. I mean, again, we'll have to see. But my instinct tells me that the Illinois Supreme Court wants these issues in front of them all at once, at one time, on a final ruling on the merits, and so they can deal with it. That's what I suspect. So I don't know that they'll take that issue up in the second district, and it's okay. I mean, what they ruled in the second district, I disagree with the opinion, but practically speaking, gentlemen, it doesn't affect anybody in this state.
Right. So if your case goes to the fourth and they rule to the contrary, now we've got two districts at conflict, and Supreme Court would pretty much have to take it, wouldn't they?
Yes, they would. And again, I believe, for what it's worth, and again, talking with, the Attorney General's office, that the Supreme Court will take this up anyway. This is an important enough issue. So even if the fourth appellate in Springfield, let's say that they would rule the same way that the second did, I see no way, again, in my humble opinion, that they don't take these issues up. It's just too big of an issue for them not to weigh in on it.
Well, before we get off to the county cases, when you look at some of the other states across the country that have been into the Supreme Court months ago, what is it with Illinois' judicial system that seems to be so slow compared to other states?
I don't know that the judicial system itself is that slow. I think that the cases that have been filed and the way that they've been managed and again, I'm a part of that, and there's reasoning for it. They've not been pushed that fast. So, again, without talking about my clients' strategies too much, there's been reasoning for that. I don't know, again, that anybody's pushed those issues really fast. And again, I have my reasoning for that of why I haven't for my clients. But again, I don't know that I could put that on our judicial system. I just think it's the nature of the cases that are present in our state right now.
Fair enough.
Next question.
The county's cases, they're all consolidated with the Bailey case, right?
They are, and that issue and as we talked about when we do an amendment here real soon, that of whether or not there's a disaster. My belief is the best way to take that issue on of a disaster is what I just mentioned when we were talking before we started recording, is that the disaster definition requires an occurrence or a threat of a particular, either a public health emergency or an epidemic. The governor started using the term epidemic now, which is a very broad term, right? And so, there's a very specific definition of a public health emergency. As you guys know, you have to have widespread loss of life or widespread significant illness, etc. The epidemic doesn't have that specific definition. So, you have to look at the general definition of what an epidemic is. And so, we'll have to deal with that. But more interestingly to me, as it relates to, again, the disaster proclamation, not the governor's emergency powers, but the disaster proclamation, is that when the governor issued the first one back on March 9th, did we have an epidemic or a public health emergency? Reasonable minds could quibble about that. But if I set that aside for a second from a medical diagnosis, and I come to his second proclamation of disaster that he issued on April 1st, what was the threat or occurrence on April 1st? Governor tries to say COVID-19. Well, COVID-19 was not a threat or occurrence that originated on April 1st. It was the same COVID-19 virus that existed on March 9th when the governor issued his first disaster proclamation. The only occurrence that we had on April 1st that caused that second proclamation to have to issue was the arbitrary deadline or end date that he put in the first one. So that fiction of saying, I'm going to cause this disaster proclamation to artificially end because the law doesn't require it to end, so I can write another disaster proclamation, I don't believe that satisfies the definition of what a disaster is in the act. And so again, having been consolidated with Mr. Bailey's case, that needs to be one of the 3 or 4 issues that need to be put again in front of the Illinois Supreme Court, under the presumption that the Illinois legislature would not deal with this issue.
Yeah, I think either or both of those need to happen, that the legislature needs to amend the law and the Supreme Court needs to decide everything based on the merits and based on the law that's in place at the time it is happening now.
I agree with you, because the legislature, if they come and do something right now, that would only address issues into the future. We still have the question since March 9th of the legality of what's been happening across the state. And again, whether the Illinois Supreme Court deals with that in itself, or whether there's also some resolve sought in the federal court, that's still something that has to be considered.
Yeah, because
if you could, Tom, in regards to that first disaster proclamation, could you share to our viewers that may not be familiar with it, did that first one have anything to do with COVID?
The very first disaster proclamation, or the first executive order?
The first executive order.
No, once the governor on March 9th issued his disaster proclamation, saying that COVID was a disaster, it then gave him the ability to issue executive orders in some fashion. And arguably he would say he was issuing those executive orders to protect the public health. However, the first executive order that he issued was to protect the marijuana industry. And so I've always been left vexed as to, with all of the issues that we supposedly needed to deal with because of the coronavirus, that we protected the marijuana industry with the very first executive order. That's always been an interesting conversation that I've had with people.
Yeah, it's interesting. The media doesn't seem to pick up on that and ask the questions. We've never been able to get an answer from their office on it.
No, the media, guys, I've dealt with the media a lot in the last 9 months. There's a lot of good people out here, that work in that profession. But for the most part, it seems like the media that I've dealt with most of the time, they've all been about perpetuating the hysteria that's been created by the state level agencies, either the Department of Health, Department of Commerce, the governor's office. They've really been writing the stories that have kind of perpetuated that whole optics that those agencies have been wanting to put out there. Absent gentlemen such as yourself who have taken the approach, you're going to write it right down the middle and be objective and critique really what's going on, which I've appreciated that you've been doing. It just seems there's not a big appetite for that in a lot of these news agencies across the state. I don't know why, but I haven't seen it. But you're right. I don't know that question has been asked a lot. There's a lot of questions that I think could be asked of the governor's office and that haven't been asked. And here, even recently, I've seen a couple of journalists ask some tough questions, and they don't really get really straight answers. But for the most part, again, there could have been a little bit more critique done of a lot of these things, and why you again issued your first order to protect the weed industry. That would have been how the governor would respond to that.
Yeah, it didn't make much sense when they say that's related to public health safety, and those 3 things that he issued, delays in timeframes for marijuana permits and things like that. It didn't have anything to do with public health.
It didn't, and for the most part, I've watched a lot of the policies that have been driven for the last 9 months, and it surprised me when I first learned that one of the main administrative agencies that I had never heard of until this all started, the Department of Commerce and Economic Opportunity, they are a lot of the brainchild behind a lot of these health-related policies, and it seems absurd to me, but I think the reason that is because while they don't want to admit it, gentlemen, the economics has been a bigger driver of these policy decisions to me than the public health, in my opinion. Again, the weed industry, people can stand in line at these weed dispensaries. And again, I don't have a problem. People want to smoke marijuana. That's their choice. I'm not critical of that. But they stand in lines. I've seen 100, 200 people standing in a line right next to each other to get in these dispensaries, why are we protecting that particular behavior? And people, again, can't go into a bar or restaurant to sit down and eat. To me, it's got to be tax-based driven. That's the only thing that makes any sense to me, and that's what I've concluded.
All right. Well, we've gone a little over 15 minutes. Is there anything else? You got anything else, Kirk?
No, I think we're good to go. We're still trying to get some data out of IDPH on, the source data. They're refusing to give us that. So it looks like under FOIA, we're going to have to file suit to get that information, but they've refused to give us the source data for bars and restaurants.
Yeah. And the bar and restaurants, as far as the positivity rates, et cetera.
Right.
Yeah.
And when they put out the pie chart and they gave a percentage of, where COVID is being, the problem areas. I don't remember what it was for restaurants, but it was like 3% statewide was the number. So we wanted the data that created that percentage, and they've refused to give it to us.
And I've delved into that a little bit, at least in Sangamon County. And the reason that I believe, and again, this is my opinion, that they're getting resistance is because they don't have it, right?
Right.
Someone tested positive for the coronavirus, and
Right.
they get asked questions. We are all intelligent people. Absent very unique circumstances, it's very hard to be able to deduce where that person would have contracted that virus. It's almost impossible. So those charts are suspect. And the one in the county that they put together, I actually got the source data for that one that said 186 people tested positive in bars and restaurants over a 4-month period. And that's what they put out definitively. 116 of those 186, their own chart says, we think they might have caught it there. They told the public that it was come from a bar and restaurant. I think at the state level, they probably have that same uncertainty, which is they don't want people to see that because, they'll see how the public would see how thin those determinations are.
Yeah.
There's something else I'd like to point out to you guys too that I think is important.
You bet.
We've been talking about executive orders for months, and for a long time, those executive orders instilled a lot of fear in the people in this state. And now, after months and months and months of hard work by a lot of people, I think the public generally is becoming to understand that executive orders cannot control their behavior. There's no enforceability to any of those. I think people are finally starting to appreciate that. So what we have now is this very small, isolated patchwork of a few counties and cities trying to utilize other types of mechanisms like food ordinances or local liquor licenses sometimes, etc., business occupancy permits. And it's not a lot. It's about 3 counties across the whole state. Of 102 counties, we've got 3, and we've got maybe 15 or 20 cities. That's being very generous, that are doing these types of things, trying to force bars and restaurants and intimidate them to close. Because again, nobody says, oh, the governor issued an executive order, I can't be open. I haven't had a client in months say that, okay, I'm closed, Tom, because governor's executive order says I have to. They're being intimidated by these very small group of county and city officials. And that's really what we need to be paying attention to right now, in addition to the governor's executive orders. But again, those orders, they're not influencing anybody's behavior right now, in my opinion.
Yeah, I concur. That's pretty much what we're seeing. We're starting to see more states' attorneys start to issue some letters, cautioning some of these, draconian rules that local agencies are trying to implement.
Well, let me give you a little bit about that, guys. I think it's important. Again, I've had the opportunity over 9 months to talk to a lot of these states' attorneys. And again, well over a majority of them. And all in all, most of them, when I say most, you can count on one hand the ones that would be different than what I'm getting ready to say to you. And I'd have fingers left over that don't take the position that these executive orders, there's no enforceability to them, right? Health departments don't enforce executive orders, and city councils can't enforce executive orders. Overwhelming majority of these states' attorneys have thought that all along, but we now have a few of them actually coming out and taking that position publicly, as you just said, Kirk. And it's, I'm glad to see that, because people have for a long time been looking for somebody to give them direction. People typically, people want to follow the law. People are law-abiding. But this confusion and this uncertainty has been exploited by the governor's office for far too long. And we now have some state's attorneys that are taking this position publicly. There's been a lot of them lately. And again, that's encouraging because, again, people are starting to understand what the boundaries are of how these things are supposed to work.
Yeah.
I particularly like the one out of, what was that down south in
Jackson County?
No, starts with an M, I think. Madison.
Oh, Madison County. Yeah.
Where it says more or less, the individual has due process rights, and so do businesses.
Yeah, that's Madison County. That's
right. I don't think I recall him saying, none of the orders are any good, or, this. He basically said everybody is afforded due process, including businesses.
Yeah, Mr.
Gosh, I think we wrote a due process article on March 15th.
Yeah, we did.
And Mr. Haynes' article, or his letter that he put out, you're exactly correct. He doesn't specifically take on executive orders. He doesn't have to. But
right.
what he says is he outlines the law, which is, one, a health department cannot make a premises off limits to the public for COVID unless they go through and get a court order under the law. We've been talking about that for months.
Right.
And he also said another thing that was important, which is, if the health department wants to try to suspend somebody's license, like a food license, for no other reason than the COVID type of issue, he's going to look very seriously at that, which means to me is he's not going to be standing in a courtroom on behalf of his health department trying to get an order against that business to close down because the food license was suspended. That's how I interpreted that, because, again, that's what they're trying to do. And again, they have been successful in Champaign and in Sangamon counties in getting those courts to say that you can't be open because you don't have a food license, and notwithstanding that the food license was taken for a complete pretext of reasons, had nothing to do with the food, and then stand there, gentlemen, and say, think about this. When we're not closing your premises off to the public that would require a court order under the law, we're just telling you, restaurant owner, you can't sell food.
Yeah.
So you can let people in for whatever reason you want. I mean, that kind of fiction and that type of ruse is unfortunate. But again, there's 2 counties at least out of 102 that have been able to succeed in that.
Yeah, those officials need to be held accountable for that kind of activity.
Yeah, I understand.
Well, I think in our county we had a case where I don't think it would get prosecuted, and our health department called the state police and had them come in and issue citations in an effort to scare the business owner, because it was a state official that did it.
On liquor license or some kind of mask?
Yeah, it was a food. It was a local restaurant serving food.
I got you. Yeah, I mean, the state liquor commission's out now because they got browbeat by the people above them that they had to go out and try to pretend to write violations of Administrative Rule 100.30. I've talked to over half of those liquor agents, and they know that it's all hollow, but they were told to do it, or there could be consequences for their employment. So I've had some clients get these, you can't be, you're open and we're going to charge you $500 fine unless you want a hearing because you're violating the rule that says here's what the rule says. Under 100.30 of the Liquor Commission Administrative Rules, if you're violating a state law, a federal law, or a local liquor ordinance, you could potentially be fined or suspended of your state license. An executive order is none of those things.
Yeah,
correct.
They all know that. They told the administration above them this doesn't work. They were told to go do it anyway because we got to act like we're doing something, or we're going to get in trouble. And so I file requests. I've had a handful of these over the last week. Send off a request for hearing because we're not going to concede and pay your $500 fine. And I likely suspect that we'll never have a hearing in front of the State Liquor Commission because they know they can't win. But we'll see.
Right.
I've been waiting for 4 months, 3 or 4 months for one of these hearings on a client. They got one several months ago, and I've asked them a few times, when's our hearing going to be? They tell me they'll be in touch, but I don't think we'll ever hear from them.
Yeah.
Either. All right. Well, hey, I appreciate you talking to us.
Thank you much.
Guy, last words of wisdom.
No, we need people to stand up for themselves. You know, you guys talked about Champaign County, which is one of the 2 counties where this health department again is heavy-handedly playing this ruse. Those people need to stand up for themselves and take their county back. They need to make this a political issue, because I assure you it is a political issue. And there's been a couple other counties up north that the county health department started down that path, and their business owners and their citizens stood up for themselves and they pushed back successfully. So that's what needs to happen in the short term.
All righty. Well, appreciate it.
All right, gentlemen. Thank you very much.
Thank you.
Thank you, sir.